Good morning, Mr. Mills.
Good morning.
Hey, I was just wondering why you're on Zoom because I know Judge Martin said this was a live hearing.
My notice to appear says Zoom.
Hmm. Hold on one second.
So how you been?
Good. Stay active. Eat white steak.
Good morning, Mr. Day.
Morning.
Good morning. This is 2302609 LT, Tommy Schramm versus Rob Mills. Would you state your names for the record, please?
Your Honor, John Day appearing on behalf of Tommy Schramm, who's here with me.
Tommy Sue Schramm.
Thank you, ma'am.
Robert Mills.
Thank you.
And Your Honor, if you don't mind, could I have Tommy sit across the table? I got a mortgage. I don't want to expose her.
That's fine. Thank you.
Thank you.
Today was a day and time scheduled for hearing on what the court believed would be Mr. Mills' motion to dismiss. We were last here on December 15th.
That's correct, Your
And
Honor.
he was supposed to file the motion by December 18th with Mr. Day to file his response by December the 27th. This court has received an answer to the summons that was filed with the court on December the 27th. Mr. Mills, did you in fact file a motion of any kind in this matter?
Yes, Your Honor. At the top, it says answer to summons, and the first paragraph says it's a motion to dismiss, so that might be the confusion. When I went into the court on the previous Monday, I was unaware that you had to pay money to file a motion to dismiss, and I was on my way to an appointment. I didn't have a checkbook. I came back on Thursday afternoon, and I missed the court. They were closed Friday, and immediately after Christmas was when I actually was physically able to file this, but I paid to file a motion, and I understand the top says summons. So I apologize for that confusion. However, I did pay to file a motion.
Mr. Day, did you receive a copy of Mr. Mills'
Yeah,
answer / motion?
Your Honor, when we were last in court on the 15th, Mr. Mills requested the opportunity to file an answer and to file a motion. And the court, and he represented that there would be no problem, that he would definitely have this thing filed on the 18th. And the court gave me to the 27th to file a response to his filing on the 18th. I had been out of the office sick, but his document that he refers to was not delivered to my office until 11/14 on the 27th, which was the day that the court had made my response due. And I was out of the office on that day sick. But this just seems to be another one of our situations. We frequently find ourselves in here with delays. I would ask the court to deny the motion is untimely and set this matter for immediate trial.
Mr. Mills, anything else?
I would say the motion speaks for itself, and I would ask Your Honor to review it and make a ruling on it. It's an improper attempt to circumvent your ruling from a previous hearing, and it's Mr. Day's second time to circumvent that ruling. There's a very simple way that they could be going about this, and they choose to attempt to run an end around continuously and ignore the elephant in the room is that I prepaid for this right to possess this property, and these shenanigans of trying to make allegations that I've had forcible entry or holding vacant property by force is ludicrous, quite frankly.
Was there anything else, Mr. Day?
No, Your Honor, not this time.
Thank you. Mr. Mills, the court takes the document as it is captioned, and it's captioned as an answer to the summons. Even if you read the paragraphs included therein as motions, Mr. Day is correct. The motion is untimely, as this court was in fact open on the 18th which was the deadline for you to file your motion. I'm just looking at the calendar. We were open the 18th, 19th, and 20th. If you had filed it even one day late, this court might consider it. But based on the fact that these are summary proceedings, summary being short and to the point, these unnecessary delays are not to be tolerated. Your motion, improperly formatted, but I'll take it for its contents, your motion is untimely, and your motion is denied in its entirety. Mr. Mills, you had also indicated previously that you were requesting a jury trial, and the court asked what the triable issue was. You indicated that that would be included in your motion, which again, the court has denied. You have not filed a jury demand, which we discussed on the record back on December the 15th. You had 5 days from that hearing to file your request for a jury demand and pay the applicable fees. You have not done that. Mr. Day is now requesting an immediate trial. The court is happy to schedule the trial as soon as the parties are able to agree to a date. I have nothing scheduled tomorrow, Thursday, or Friday. Tomorrow,
Your Honor,
Thursday,
if
or
I may.
Friday. Yes, sir.
Your Honor, if I may,
Yes, sir.
I've paid for a jury demand on this issue 2 times. I asked when I filed this on the 27th, I asked the clerk if one of these receipts would be applicable to this existing case, and she said that I would have to ask you that on the 2nd. I just didn't want to pay $50 for a 3rd time for something that I've paid twice and have been told I can't get any refund for. And it quite frankly, I feel it would be fair that I paid more than twice for a jury in this matter. So
Well,
that's the reason I didn't
Mr.
pay the additional 50 the 3rd time for this jury demand, is because of the fact that I paid it twice. And as far as triable motions triable motions, I mean, it's quite simple that it's a tenancy dispute. I'm disputing that I've prepaid for this lease of vacant land. And from what I could interpret in my layman's terms of MCL 554.633 subsection 1, you can't limit or restrict a landlord or a tenant from demanding a trial by jury on tenancy disputes. And that's exactly what this is. The plaintiff has alleged that I am holding property by force. I deny that allegation. There was no forcible entry, and there's no possession held by force after a peaceful entry. Again, in my motion, it says that applies to residents who live in a dwelling, specifically friends or family who refuse to quit living in a residence after their stay was extended and they've been asked to leave. This is a vacant piece of property. I'm not holding it by force, and that's my dispute. And I demanded a jury, and the only reason I didn't pay the $50 is because I paid it twice. And I don't think it's fair or reasonable to have to pay it a 3rd time.
Mr. Day, was there something you wanted to say?
May I just check my calendar real quick? I think I'm available on Friday.
Yes,
I
sir.
think that
Thank you.
Mr. Mills, why, let's see how, why Mr. Day is away.
I'm sorry.
Your Honor, I am available on Friday at the court's pleasure.
Thank you. Mr. Mills, I'll try to answer your questions. Each case filed in this court, well, in any court, is its own separate, distinct, unique case. Full stop and period. So the jury fee that you paid in the first case that were filed between these parties that was here over a year ago now, was you filed a jury demand. We didn't get the jury because you were successful in your motions to dismiss. Then there was another case on this court's finding that you had not been given adequate notice, and that only applied to that case. The case was filed a second time, and it was heard before Judge Oakley. I don't know what happened in that case. I don't know how the parties resolved it.
It
So
was
if you made a
dismissed.
jury demand, it was dismissed. I don't know if it's Mr. Day, was it dismissed by stipulation or was it dismissed on motion?
It was dismissed after a hearing, Your Honor. The judge ruled that that case was on hazardous maintenance of the condition or the property's condition. And the court ruled that the facts he did not believe warranted the statutory definition of hazardous use of the property. So he denied it for that reason, pointing out that he felt that under the circumstances, this was more akin to being a squatter case, and directed us to give Mr. Mills an opportunity, as he had again represented he wanted to buy the property, to make an offer, which he didn't do, which left us with the only relief available, which was to come back to the court once more and try to petition to reclaim this property.
So, Mr. Mills, it sounds as if Mr. Day's assertion as to what happened with Judge Oakley are accurate. It sounds as if you, excuse me, it sounds as if you were the prevailing party in the second case. So this is a third case filed as a request to recover property, indicating that you made forcible entry and you have held the property by force, or have held the property by force after peaceable entry. Mr. Day did attach documents that indicate that there are other agreements that you've presented regarding how you came to be in possession of this particular piece of property. This is a separate and distinct case with separate and distinct allegations being made. So this court would not have allowed the jury fee paid either in the courtroom one prior case or the Judge Oakley case. So you needed to file your jury demand and make payment as indicated and on the record when we were here on December the 15th. It clearly says you were to file the jury demand and pay the fee. Answer and motions by December 18th. That was not done. When you don't comply with the court rules, you waive the right to have the jury trial. Period. The next part is Mr. Day has made the request for an immediate trial in this matter. I can't force a trial in less than 7 days unless the parties agree to it. I said, Mr. Day, I was available, but I know I realized that you have to adjourn it for at least 7 days.
That's fine, Your Honor.
That being the case, Mr. Mills, we're looking at next week, a week from today. Mary Ann?
Yes, ma'am. I'm looking, on the 9th, you are open.
That's next Wednesday? Or next
Tuesday.
Just let me check.
Mary Ann, I'll step off and grab some calendars. Mr. Mills, check your schedule for the 9th.
I am available on the 9th, Your Honor.
I wasn't in the courtroom, Mr. Day. What did you say about the 9th?
I am available on the 9th, Your Honor.
Mr. Mills, are you available on the 9th?
Well, I'm scheduled to work every day that week, Your Honor. But in the meantime, obviously I have to make myself available for this matter. I'd have one last question for you. If and when I come down to the court today and file a motion for a jury and pay this $50 fee, am I being denied the right to have a trial by jury? I'm curious to, I mean, we talked about the 19th when we were last in your court. I made it very evident and clear that I was going to request a jury. I've requested a jury 3 times now in this matter. And the only reason I didn't pay the money when I was down there is because they told me to ask you if, you know, they couldn't answer my question as to why I wasn't refunded if I didn't get a jury and why I couldn't apply it to this case. You've explained your your reasoning why I can't, and I accept that reasoning, and it's valid. I don't understand or agree why I didn't get refunded. However, I still want this jury trial, and I'm going to come after I get done working and pay and demand a jury again, just to have that on the record that I don't want to be denied my right to have a jury hear this matter and resolve it once and for all, so I don't have to continue dealing with this. I am not the one that's misinterpreting facts here. Mr. Judge Oakley didn't say anything about a squatter. I made a motion to dismiss. He granted it. But that's neither here nor there. My question is, if and when I come down and pay for my jury fee for the third time on this matter in a third separate case, are you going to deny my right to have that trial by jury before we schedule this? Because that's what my intentions are today.
Well, Mr. Mills, I'll break your multiple part question down. I would never sit here and say that I would grant or deny a motion that I haven't seen, reviewed, and the other side had an opportunity to respond to. That's number one. Number two, the complaint that was served in this matter indicates to you as the defendant/tenant, if you wish to demand a jury trial, you must file a jury demand, and it identifies the form number as MC-22. So I'm not denying your request for a jury trial. What I'm saying to you is that you have to do certain things. You saying in hearings that you want a jury trial, there is a form that you have to file. We discussed this on the 15th of December.
I understand.
If you have questions about the refund of the $50 in the two previously filed cases, I would expect to see a motion or a letter to the court if you don't know that you need to file a motion, a letter to the court, or some other action in those specific cases. You can't come into this separate freestanding case and say, this case isn't on your docket, is not noticed up, but go into these two prior cases and move money over here. That's not how it works. So I will never say that I would deny a hypothetical motion or I would grant a hypothetical motion. It's not here. I don't know what you would put in your motion that I would rule on it one way or another. But again, a motion filed in this case has to be served on Mr. Day. Mr. Day has to be allowed the opportunity to respond. Because there is not a jury trial, a jury demand filed and paid for in this case, 2302609 LT, this court, in response to Mr. Day's demand this morning, is prepared to schedule an in-person bench trial on a date that the parties can agree to. So.
Fair enough, Your Honor.
And if you're saying that the 9th is not good for you because you work all week, my question to you is, when are you next available for a block of time to have a trial in this case, an in-person trial? Because there are allegations that the lease that was signed by Ms. Schramm's husband that you presented in this courtroom previously is not the only alleged document that was executed regarding your use, possession, occupation of the property. So when we're having a document heavy case, I prefer to have the parties in person. When are you
Fair
next
enough.
available, sir?
When we last spoke, we spoke about the 19th, and I penciled that into my schedule as clear. I would say the 19th works for me, and Mr. Day indicated it was fine with him last time we were here, Your Honor.
We talked about the 19th. Mary Ann, why do I feel like there's a jury trial already on the 19th?
Because there is.
There is a jury trial already on the 19th. That's why. The 18th?
The 18th will be fine, Your Honor.
Mr. Day will check his schedule. Mary Ann will double check our schedule.
You're good, Judge.
Thank
I
you.
want to be fair to Mr. Day and let him know my intention to file that motion to demand a jury today. I don't want to spring anything on him.
Your Honor, I am open on the 18th as well.
The 18th at 9 a.m. in person in courtroom number 1. January 18th is a Thursday at 9 a.m. in person. Mr. Mills, please be prepared to proceed with trial on that day with all necessary documents and witnesses. Mr. Day, I'm sure you've heard Mr. Mills indicate that he intends to file a motion for a jury trial.
I
If
heard
he
him.
files that motion,
I heard, Your Honor, and the reason we had that other date, or the 19th originally discussed, was the court needed time to send out notices for a jury trial. So the issue is going to be, right now, we're set, I'm assuming this date of the 18th is now a non-jury trial. So are we going to then have to go back and give us a new date down the road if the court does grant the motion for a jury trial?
the short answer to what this court would do to a hypothetical motion, if it became that the trial on the 18th, you're correct, sir, is a bench trial, it's a non-jury trial. If Mr. Mills files a motion, you have the opportunity to respond to it, we can take it up on the morning of the 18th. If the court grants the motion, the hypothetical motion, to allow him to file the untimely jury demand, it does take 3 weeks for our jury clerk to summon jurors. This courtroom number 1, is only allowed to schedule juries on certain weeks because of the availability of space, the availability of staff to effectuate a jury trial. So yes, sir, that would necessitate an adjournment of the matter, and the court would reconsider your prior request for bond or for escrow payment to be posted.
Thank you, Your Honor. I recognize the unique nature of this case. I believe there's also a court rule that allows for posting a bond when there's a potentially frivolous cause of action. And I would like to get some kind of a relief that if my client has to go through yet another month or more of delays in this case, while he continues occupancy, that there be some money to reimburse her, since she has not received any money from Mr. Mills in well over a year. Almost 2.
Mr. Day, I appreciate that was the allegation that was contained in your addendum to the complaint. This case was not filed as a non-payment case, and I did not see a supplemental complaint or a request for money judgment in my review of the file. Maybe I'm mistaken, but
yeah, no, my request for that wouldn't be for that. It would be for bond for costs and attorney fees for frivolous action.
again, Mr. Day, you may renew your motion when we appear on the 18th. If we need to take it up on the 18th, we'll take it up on the 18th. I'll make notes that is in fact the conversation we've had this morning. Was there anything else on behalf of Ms. Schramm?
No, Your Honor, that's fine for today.
Mr. Mills, was there anything else, sir?
No, Your Honor.
That concludes this matter. I will see you here in courtroom number 1 on Thursday, January 18th at 9 a.m. Have a good afternoon.
Thank you, Your Honor.
Thank you.
And Mary Ann, that concludes our docket for the day. We stand